Welcome to today's program titled Developments in EEOC Enforcement in 2023 from Charge Investigations to Systemic Litigation. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chris DeGroff. Chris, please go ahead.
Thank you, Kate. Good morning and good afternoon to all of our friends, depending on what your time zone is. Welcome to our EEOC webinar. We've been doing this by my count for about 11 years now. It's always one of our more popular webinars, and this is one of our largest turnouts ever. So welcome. We hope you find it useful. We have a lot of ground to cover today, so let me get right into introducing our panel. We have Andy Scroggins here with us today. Andy is a partner in our labor employment group who defends employers against class and collective actions for claims of discrimination and also wage and hour violations. He has special expertise in EEOC systemic investigations, including some that have lasted, unfortunately, over a decade. And he also has a considerable experience defending cases brought by the EEOC in federal court. We also have Matt Gagnon here with us today. Matt is a partner in our Chicago office, specializing in labor employment litigation for the full range of legal theories, but with a special emphasis on equal pay matters. He's also a frequent speaker on the topics we're going to be discussing today. We have Sarah Baumann. She's also a colleague in our labor and employment group, specializing in class action defense. She has extensive experience in EEOC proceedings. Sarah also specializes in privacy-related litigation, including biometric privacy statutory actions, and she's a frequent author on the issues we'll be talking about today. My name is Chris DeGroff. I'm your moderator today. I get to play Chuck Todd. I'm the chair of our complex discrimination litigation practice group. That's a mouthful, but it's a national think tank about large-scale discrimination matters, and all of our panel members are members of that group, and I'm very proud to work with them all. I also chair Chicago's labor and employment department. I focused a large part of my practice for the last 25 years on EEOC enforcement actions across the country. Kate mentioned at the beginning that there's a questions feature. I invite you to ask questions as the day goes along. I'll try to field those, or the panel will try to field those as we go. If for whatever reason we don't get to your question, we try to reach out to you by email after the presentation's over. Okay. Can we have our next slide, please? Okay, just quickly, this is a lineup of what we're going to be covering today, including the makeup of the EEOC. We're going to go through charge data and conciliation. We'll talk about EEOC litigation trends and the EEOC's strategic enforcement priorities, and then some of the emerging issues that we see and things to come throughout the rest of the year. Can we have the next slide, please? Okay, let's start with the EEOC's lineup. I'm going to throw it over to Andy Scroggins. Go ahead, Andy, and we can take down that slide.
Thanks, Chris. The EEOC's leadership, the commissioners, matter because they dictate the enforcement priorities for the agency. And one interesting thing to keep in mind about the commission is that control doesn't change with an administration. When a new administration comes into power, they are able to designate the chair and vice chair for the commission, but they don't get to flip the majority control of the votes. And so, although Biden's been in office now for a couple of years, there hasn't been a point yet where there's been a majority of Democratic appointees who can set the direction for the commission. So we have right now a chair, Charlotte Burrows, who was appointed by President Biden. The vice chair is Jocelyn Samuels, also appointed by Biden. But the two other commissioners are Keith Sonderling and Andrea Lucas, both of whom were appointed under the Trump administration. There's a vacant seat right now. Janet Dillon, who was the former chair during the Trump administration, left that seat in November of 2022. There was an attempt to fill that seat last year in April with Kalpana Katagal, who is a partner at Cohen Milstein, which is a well-known and well-respected plaintiffs firm. That nomination was made in April of 2022, and she never got out of the committee because of the nearly even split in the Senate at that time. She was renominated in January of this year and is expected to be appointed at some point this year, but that's still pending. So right now we have a tie vote here with the commission. So why does that matter? Why does it matter that you have a deadlock here? That's because cases that the EEOC regional directors and the general counsel want to take to litigation need approval from the majority of the commissioners. And right now they can't get that. It's a deadlock. So when that control changes, it's possible to present cases for approval by the commissioners and have them go to litigation. And we may even see some rule changes. So some interesting background. You know, it's not the case that the commissioners have been refusing to approve litigation. We've seen that they do, but there were, I forget the count, maybe 18 instances over the past couple of years where the general counsel asked for approval to proceed to litigation and didn't receive it. And in that case, then, you know, the case needs to be resolved in some other way. So what we think has probably happened is that some of the more savvy regional directors and regional attorneys around the country decided that if they had a case they really wanted to pursue, but they weren't confident that it would get approval, that they're holding back and waiting until there's a group of commissioners who they think are more likely to give approval to go forward with that litigation. You know, another factor that's important to keep in mind as we think about what's in the future for the EEOC is that they did receive a budget increase for fiscal 22. And so they have more resources at their disposal. And when we get to that point where full control gets to the hands of the Democratic nominees, we expect that those resources are going to be directed in a way that results in more litigation and just more enforcement activity generally against the employer community.
Thanks, Andy. And also we have a general counsel that's waiting to be confirmed as well. So the general counsel is a fairly important role as well, especially, and we're going to get into this a little bit later on, if that litigation authority gets pushed back out into the field, the general counsel's role is all that more important. So thanks, Andy. So Sarah, let's talk a little bit about what we're seeing with charges. Most of our participants today have dealt with charges in one form or the other, but tell us a little bit about the charge data. And Kate, if you could bring up slide 6, please.
Sure, Chris. So EEOC charge data is reflective of how American workers feel about how they're being treated by their employers, as opposed to EEOC filing statistics, which is more so reflective of what the EEOC is prioritizing in terms of their strategic and political agenda at the time. So both are important stats to follow, but for that reason, they're analyzed a little bit differently. And the reason why charge numbers reflect how workers are perceiving how they're being treated is because it's the first step in the process of initiating a lawsuit against your employer. What a person puts in his or her charge describes the conduct that the person feels that they have been experiencing and why they believe it violates the law. So in terms of the types of charges filed with the EEOC, retaliation is consistently the most common allegation. Retaliation occurs when an employer subjects someone to what's called an adverse employment action or a significant change to the terms of their employment in some negative way. And typically that's the result of an employee engaging in protected activity. And most classic example of this is if an employee feels that he or she is being discriminated against, he or she reports it to their employer or files a charge, and then as a result, that person is terminated. So these types of claims accounted for approximately 24% of all charges filed in fiscal year 2021. The next most popular charge types during that year were disability discrimination, harassment, and then race discrimination. So as you can see from the chart here on your screen, the amount of age, race, religion, and sex-based discrimination charges have remained relatively steady over the past 5 years, but the type of charge that is becoming more prevalent is disability discrimination, and that accounted for over 37% of all EEOC charges in fiscal year 2021.
And Sarah, isn't it true that the charge data doesn't just show where the EEOC is headed, but also it's the first step in private litigation, which is probably where most of our attendees have encountered charges. So knowing what your charge data is telling you is an essential early warning system for what might be coming down the pike in terms of private litigation as well. Why don't we go to the next slide, and Sarah, maybe you could tell us a little bit about what we're seeing here.
Sure. So with respect to where these charges are being filed, there are certain geographic hotspots in which the employees consistently file the most EEOC charges across the country. These states are highlighted by the map graphic shown on your screen. So in fiscal year 2021, Texas outpaced the rest of the country by over 1,500 charges, and the top 5 states for charge activity during that year in general were Texas, as I just mentioned, and then Florida had 4,941 charges. Pennsylvania had 3,960, and then California and Illinois weren't far behind. But when you adjust this data to account for state population, the southeast region of the country led the way in terms of EEOC charge filings per capita. So we just put our EEOC initiated litigation book out this past January for the past fiscal year, and that includes additional data analyses for those who are interested.
That's a great point, Sarah, on the book. Just everyone's going to get the link to our to the e-version of our book, but if you want to do a deeper dive into any of these statistics or benchmark your own charge data against what we're seeing nationally, that's a good source for that. If we could take down that slide, please. Andy, the next subject is conciliation, and I would bet probably a good third to even maybe half of our attendees today have gone through conciliation at one point or another. First of all, tell us briefly what is conciliation, and then what we're seeing from our Seyfarth analysis of the data on that.
Yeah. So the EEOC is required by its statutes when it issues a letter of determination to try to reach a conciliation result with the employer who received the charge. So try to negotiate a settlement on behalf of the person who filed the charge, rather than taking the matter to litigation or just issuing the person the right to sue. What's interesting, though, is the EEOC doesn't publish any information about how long it spends in conciliation when it issues that determination. So what we've done is to comb through the EEOC's complaints that it files in federal courts to pull out some of the breadcrumbs that they've dropped in those documents and try to piece it together. So it's not the full universe because we don't know about those that did resolve before they go to litigation, but it gives us some insight. And remember, what employers want here is a longer conciliation period, right? Because they want to have the opportunity to try to resolve it before it goes further to litigation, and not have the EEOC just kind of hand wave some effort to get it resolved. So what we saw is that across the country over the past fiscal year, the average is about 4 months that the EEOC spent trying to reach a conciliation agreement.
I'm sorry to interrupt. Kate, can you bring up that slide? I think we've got a graphic on this.
And what you'll see when that slide comes up is that, and I think there's a second piece to it, is that just like the other aspects that we've looked at, a couple more pieces to pop up there. Geography matters. So even though the average time that's spent in conciliation is 120 days, you'll see that there are some regions of the country where you'll get a significantly greater amount of time to try to reach that result, where they seem to spend more time engaging with employers. And then the flip side of that, of course, is that you get some regions that are giving it only a cursory effort before they declare that conciliation efforts have failed. Miami is a real standout here, giving only 37 days on average to conciliation before it moves on and proceeds to litigation. So if you're in a tricky charge negotiation situation, look to the office where you're having those negotiations to try to size up what your odds are. And obviously, we'd be happy to talk to anybody about things you might be able to do to get a little bit more time to try to reach a result before you wind up in court. Excellent.
Thank you. And we've got a couple questions while we were talking about charge data, whether it was affected by COVID. We definitely did see a dip during that period and a rebound after COVID. Remember, there's a 300-day window, so there's always a lag. And someone asked about how often charges are successful where you have a cause finding. It's a tiny fraction of the number of charges. Most of them are no cause. And I don't have that statistic handy, but I can get it to you offline afterwards. Okay, next slide, please. And let's talk about the charge of the EEOC litigation by the numbers. Sarah, you're back up.
Sure. So as I mentioned earlier, we also track EEOC filing data each fiscal year. And that's analyzed in terms of the statutes and theories of discrimination that's being alleged. The chart here shows the number of lawsuits filed according to the statute under which they were filed. So like, for example, Title VII, ADA, those are a couple big ones. And the analysis of this data can often reveal how the EEOC is shifting its strategic priorities. And in fiscal year 2022, we saw the total number of filings for that year, which was 95, decrease a sizable amount from fiscal year 2021, which had 114 total filings.
Okay, next slide, please.
Yeah, let me take this one. I think the other thing that we do, in addition to just looking at total numbers of filings and when they're filed, we also break down the filings by the type of statute under which it's filed. And then because Title VII cases make up the lion's share of the statutes, we also break that down by the theories of discrimination alleged under Title VII. So that's what you see here. Percentage-wise, these numbers are pretty ordinary compared to other years. So although all filings are down over the last few years, just as a total number, percentage-wise, they remain relatively consistent. I think the Title VII cases here make up about 65% of all filings. That's very consistent with prior years. They're usually between 55 to 65%. ADA cases are almost always the second most filed case. And again, this is fairly consistent, maybe a little bit down. This is about 30% of all cases filed. This year, we usually see about 30 to 40%. The big outlier here is the ADEA cases and also the EPA cases. So the ADEA cases, we have a big uptick from 1 to 7. But that should be seen in context. It's more of a return to normalcy as opposed to any kind of an outlier. I think in the prior 2 years before last year, there were 7 ADE cases both. So this is just a return to that standard. Same with the EPA cases. We see an uptick from 2 last year to 6 this year. It had been low for a couple years, 2 in each of the last 2 years, but prior to that, it had been between, I think, 5 and 11 filings each. So we're seeing a return to normalcy, and I think most commentators would agree that they expect to see more EPA filings under the current administration.
And so everyone's clear what we're looking at here. This is actual lawsuits filed by the EEOC versus the charge data that we were looking at earlier, which is actual employees or applicants who are bringing those actions. We got a question about whether we saw a uptick in COVID-related charges. The answer has been surprisingly small number of COVID-related charges. And I bring that up also to mention that the EEOC has also not been very active or aggressive with COVID-related filings. Matter of fact, there was a very clear message sent by the EEOC in the midst of COVID that they weren't going to use the litigation as a hammer for struggling employers trying to deal with the pandemic. Now, they said that then. There's still a long lag time. Will we start to see a lot more COVID-related cases? Maybe, but we're not seeing it yet. Could we have the next slide, please? Okay, this is one I'll take. With EEOC litigation, we often say that it's all a question of location, location, location. The EEOC is broken up into districts or regions, depending on who you're talking to. Each of the EEOC regions has its own set of priorities and has its own litigation profile that varies significantly with geography. Phoenix, New York, Chicago, and Philadelphia have historically been extremely aggressive, and they have a larger number of systemic cases. This year we saw with the data here that that followed what we expected in terms of Chicago and Philadelphia, but we saw a big jump in Charlotte this year as well. Actually, Philadelphia dropped a little bit from where it was trending last year. Still 7 is a respectable number. I have a feeling that has more to do with the fact that it filed so many cases over the last couple of fiscal years, and now these cases don't go away same year. They're usually 3, 4, even sometimes longer than that, years to get through the litigation pipeline. So with limited resources, they have to deal with a whole inventory of cases. Anyway, we do track all of these trends in our book as well. And we invite you to take a look at that. This group put together a district by district profile for each one of the regions, and we invite you to take a look at that. It gives you some insight into what's happening in the individual areas. Okay, next slide, please. Oh, here we have the CLE code. If everyone could make sure you write this down, it is, as you can see here on the screen, SS6559, SS6659. Okay, next slide, please. We want to discuss the EEOC's strategic priorities now. It's really important to drill down into these as they shape the EEOC's policy and litigation behavior. And when the EEOC evaluates a charge or a case, they always have these strategic priorities in mind. We have this list in the book, and I'm going to actually we're going to take down that slide for now because we're going to just discuss each one of these in turn. Why don't we start with, Andy, can you tell us about that first strategic priority, please?
Sure. And, it's important to remember that the EEOC publishes strategic priorities that reach out for the next 5 years. And we're now on their third such plan. They just finished taking comments on the proposed plan recently. So those 6 categories have remained the same across all 3 plans, but the details within each one have changed. So the first one we're looking at here is recruiting and hiring, and that really does span just the whole breadth of the employment relationship and formation of the employment relationship. So as we all know on this call, the EEOC is not just looking out for employees, but also for applicants. There are a few wrinkles that the EEOC has talked about, as in particular as it relates to this category for the upcoming SEP. One of them in particular is that they have a real renewed focus on looking at the use of artificial intelligence broadly defined. So it really means anything that's computer assisted or machine assisted as it relates to employment decisions. So some of the examples that they called out in particular are the use of technology to target job advertisements. And is that being used in a way that prevents some audiences from learning about job opportunities? But they're also looking at screening tools, the use of AI or any other kind of computer-based system to evaluate candidates, prioritize potential candidates for review, and then obviously making decisions with these tools as well. Keith Sonderling, one of the commissioners, has really made the use of AI one of his pet issues. And he's been very clear that he sees both the potential advantages coming out of AI, but also the potential for harm if it's misused or not understood properly. This category also includes looking out for vulnerable workers, and that'll get discussed in some other parts too, but the EEOC wants to make sure that people who want employment opportunities have access to those opportunities, and that employers are not improperly using different steps to exclude people from their workforce.
Andy, you mentioned vulnerable workers. The EEOC has defined these vulnerable populations as those who don't traditionally have access to the legal system or may not know their rights, be that because of language barriers or big power differentials within an industry. But Matt, could you tell us a little bit about your views on the EEOC's focus on vulnerable workers?
Yeah, it's a good example of what Andy mentioned in terms of the changes that we've seen over time. And I think vulnerable workers potentially is the one that we've seen change the most. And if you think about it, who is a vulnerable worker? That question can have a lot of different answers. And so the question then really becomes, what has the EEOC chosen to focus on as vulnerable workers? Over the past decade, we've seen this mostly be about the protection of employees against religious bias in the workplace. And that's especially Muslim employees. And in fact, as Andy mentioned, sometimes they add little elements to their strategic priorities, and they did add an element specifically relating to Muslim employees a few years ago. And I think many people think it relates to the ongoing wars in the Middle East at the time and the concern that the EEOC had about whether there'd be any backlash in the workplace against Muslim employees due to that. We've also seen a focus on national origin discrimination, especially that which is exacerbated by political and cultural developments around the world. I'm thinking in particular that of the COVID pandemic and the EEOC's worry about potential backlash against Asian ethnicities due to that pandemic. So that was something they had mentioned. And then, of course, protecting the rights of immigrants, as Chris mentioned, language barriers, et cetera, has always been a concern for the EEOC. And in fact, probably makes up the bulk of the case law under the vulnerable workers category. Lately, however, we have seen a renewed interest by the EEOC in focusing on religious discrimination, religious rights, and in particular, as an outgrowth of the Bostock decision, which held that discrimination against on the basis of sexual orientation or transgender status was a violation of Title VII. It was a form of sex discrimination. And so we're going to talk a little bit more about that later on, but that is a new interesting development by the EEOC that vulnerable workers could include those who are most impacted by the wake of the Bostock decision.
And that is a good segue to emerging issues, which as a teaser, we're going to talk about that as a standalone topic here in a little bit. That's the EEOC's third priority. But Matt, why don't you also tell us a little bit about the EEOC's focus on equal pay?
Yeah, for years now, we have been warning employers that equal pay is going to be a high priority for the EEOC. We continue to believe that. During the past administration, we did not see the uptick in lawsuits that we were expecting to see, but all signs point to this still being top of the EEOC's radar. I also believe that it's going to be important in the next few years because of the interesting developments that are happening in equal pay law at the moment. So especially with respect to the two different statutes that the EEOC can sue under. There's the Equal Pay Act and Title VII. And the interplay between those two statutes, the different burden shifting mechanisms, all of that is in flux right now. And to me, it seems ripe for the EEOC to get involved and try to put their thumb on the scale in favor of employees bringing those types of actions. So I do think we're likely to see more EPA-focused lawsuits and those that are geared towards more technical aspects of trying to define those laws and those claims.
Thank you, Matt. How about preserving access to the legal system, Andy? Why don't you pick that one up?
Sure. Let me first tag on to something Matt just said, which is I do think that we'll see an uptick because of all the efforts around the country related to pay transparency. We know one of the biggest barriers to equal pay suits is people just don't know that they're paid less, right? And as more and more pay transparency rules are put in place, more and more people will learn about differences and might go to the EEOC over those concerns. So yeah, the EEOC is also very interested in making sure that people are able to go to the EEOC and make their complaints. So one of their priorities has always been to make sure that any barriers to taking advantage of what the EEOC does are reduced. So when we see the retaliation claims, charges that are so prevalent, the EEOC takes an interest in those because they want to send a message to employers that if they treat someone poorly on account of a charge they raised on another basis, that will bring on the wrath of the EEOC. So we see often when there is litigation that's brought on behalf of an employee by the EEOC that they will include a retaliation charge or retaliation component because they want to make that clear. But there are also more kind of policy related issues that the EEOC will keep an eye on. So, if they have an opportunity to review a release that an employer may have tried to enter into with an employee to resolve a dispute in the workplace, the EEOC will take a close look at the language of those releases to make sure that it's not infringing on what they think are their responsibilities in the workforce. And so one common example you'll see is in a release making clear that even if a person has waived their right to obtain monetary relief by working with the EEOC, that they're not prevented from sharing information with the agency to support an investigation into either conduct that they say has impacted them or someone else. And then the EEOC also has a proactive arm. We've touched on it a bit here today, where they do try to reach out to employees where they are, make sure that they're aware of the rights that they have and how they can take advantage of those rights, either through the EEOC or through other agencies with similar missions.
Excellent. And Sarah, how about systemic harassment?
Sure. So harassment continues to be one of the most frequent complaints raised in the workplace, particularly sexual harassment in recent years. In this past fiscal year, there was a total of 16 EEOC-initiated cases that involved harassment claims, and then 11 of those were sexual harassment. So the EEOC, throughout the past, decade, has had plenty of opportunity to shape the law regarding sexual harassment through its litigation activities. And for these types of cases, it centers on two issues. The first being whether the alleged conduct rises to the level of unlawful harassment such that it can support a claim under federal law. And then the second being whether an employer can be held liable for harassment perpetrated by its employees. So as to the first issue, the conduct alleged has to be severe and pervasive. So it can't just be a few inappropriate comments over 1 year that a coworker says to the plaintiff. It has to be conduct that would create an abusive situation for the employee. And the point of that is so, employees aren't just filing federal lawsuits and succeeding on claims when really it's not abusive, but it might be unprofessional and offensive. But in order to, have a federal lawsuit, it has to be that conduct that is abusive and really affects, your everyday experience at your job. And to the second issue as to whether an employer can be held liable, there has to be some basis for the actual company to be, to be held liable under any sort of statute. And typically that'll happen if, the company is made aware of the conduct and then fails to act or fails to implement some sort of measure to prevent it from occurring again. Or another example is if the employer just doesn't have any sort of policy against this type of behavior. So there's no employee handbook that says, that lays out a reporting procedure for employees to, complain about this sort of conduct. That's another situation where an employer can be held liable. So we can expect a lot more activity from the EEOC with respect to these claims. The proposed fiscal year 2023 through year 2027 strategic enforcement priorities, which Andy touched on earlier, now expressly calls out harassment based on pregnancy, gender identity, and sexual orientation. This wasn't the case, a decade ago. So the EEOC has also articulated more detailed support for employer training in those respects, and then just general, harassment training. And that includes providing education, technical assistance, and policy guidance. And that kind of goes back to the point I made about employer liability. It's very important to develop these sort of policies to refer to the EEOC's guidance in that respect. So, you can avoid this sort of liability if faced with a lawsuit. And importantly, so, you can prevent this sort of conduct from happening to your employees.
And I thought with the systemic sexual harassment, where we've seen a lot of litigation, is the intersection between vulnerable populations and these sorts of claims. We saw a number of cases in up and down the West Coast in agricultural cases where supervisors were harassing or allegedly harassing individuals that didn't speak English. We also see a big pocket of litigation in the hospitality industry, particularly young women being harassed in restaurants. The common denominator with all of these is a power differential and a reluctance to report it. And if the EEOC sniffs out any of those kinds of allegations, it jumps all over those. So consider your business and your business model. If you've got a very decentralized situation, or if there's folks in the field, or there's any of that big power differential, and that can happen in the white collar workplace as well, don't get me wrong, you should be particularly cognizant of the risk there and take your best practices, and we'll talk a little bit about best practices.
Another one,
please.
I would add in a historically non-diverse industries. And so we've seen focus stated both in the SEP and in some recent filings going after the construction industry, which is receiving a lot of federal funding right now and historically has had some racial barriers to employment. And so that may be another focus area.
Yep. Yeah, that's a great point. Look, when we looked at our attendee list today, almost all of you are a household name. When you're a household name, that makes you a big litigation target for the EEOC. They want to find the case that splashes a name that we all know in a press release or in a lawsuit. So you already start at a certain level of vulnerability there because you're under the microscope, because they want to use that sort of secondary deterrence concept of making other folks not want to follow in those litigation footsteps. So again, just keep your antenna up for those. Could we bring up the next slide, Kate, please? And this was something that we punted on just a second ago about the emerging issues. And I think that there's no other area that quite gets the EEOC's attention than this concept of emerging issues, because it's really, the EEOC views its mandate to push the edge of the envelope and push the boundaries of the civil rights statutes to fit the modern day workplace. And so it looks for these opportunities. And why don't we start, Matt, with the discussion of religious rights and LGBTQI plus dynamics here.
Yeah, I think this, to my mind, is probably the most important and significant development in EEOC litigation over the last few years. For almost a decade now, we've been reporting out in these webinars and with our book that the single most important emerging issue has been the EEOC's focus on these LGBTQ issues. For a long time, they were just sort of building up to this Bostock decision, which finally they had a major victory where the Supreme Court sided with the EEOC's position that, in fact, discrimination against LGBTQ people is tantamount to sex discrimination. And now the question has flipped. It's turned to, okay, now that we have that decision, what is going to be the fallout of that decision in the American workplace? And in particular, what are we going to do about a potential apparent conflict to some between an employee's religious rights and the rights now enshrined by the Bostock decision in Title VII protecting LGBTQ employees? And so how has that shaken out? Well, we have gotten a few interesting decisions already, and one of them is this Texas versus EEOC case. So Texas came out and they challenged the underlying basis of the EEOC's guidance released after the Bostock decision, which touched on various aspects of the employment relationship. Texas was challenging whether Bostock should be limited to just the bare bones conclusion that one cannot terminate somebody on the basis of transgender or sexual orientation status, or whether it also protects the conduct associated with that status. I'm thinking in particular about bathroom use, pronoun use, healthcare issues relating to transgender transition, et cetera. All of those issues, these conduct-related issues, Texas claimed was really not decided by Bostock. And so any guidance that comes out and tries to expand upon Bostock is really going beyond the basis of that opinion and should be stopped in its tracks. The Texas judge hearing that case agreed with Texas on this. But I think many commentators believe that this is the first shot in a long war where we're going to try to figure out how this trickles down into the workplace. We have a few of these other decisions here, and they're listed on this slide, and they relate to a very similar issue. Now, they're not as broad-based as that Texas lawsuit. So the Christian Employers Alliance, for example, was a consortium of religious institutions that got a preliminary injunction enjoining enforcement of healthcare guidelines and regulations regarding transgender healthcare decisions. And the other one up there, Bear Creek Bible Church, is similar. It was in favor of an employer who claimed they were exempt from some of the requirements that are now exist under Title VII because of Bostock due to the fact that they're a religious organization. Fascinating subject. It's going to keep coming up. It's one that all employers need to be having an eye on.
Thanks, Matt. The next emerging issue is we're going to talk about is pre-employment screening tests, and I'll throw out there that the EEOC has said that it is uniquely positioned to do these sorts of hiring cases, mainly because the plaintiff's bar doesn't want to touch them or is not all that interested. They're expensive cases. They involve experts. So the EEOC tries to fit in that gap in private litigation coverage. But Sarah, why don't you tell us a little bit about that area?
Yeah, so an emerging issue recently, well, it's actually sort of a re-emerging issue because it's flown under the radar for some time now, but it seems to be making a comeback. And we saw this last year with the EEOC versus Stan Kogan Sons Trucking case, and that was in the District of Minnesota where that was pending. But in that case, the EEOC alleged that the use of a physical abilities test had a discriminatory impact on female applicants, and the EEOC introduced statistical evidence to prove their theory. So since this case, at least one federal court has issued a decision in a case involving a theory like this, and that case was in the Northern District of Illinois. It is called Simpson versus Dart, and there the court granted the plaintiff's motion for class certification for a class of applicants who sought employment with the Cook County Department of Corrections. And the plaintiffs there argued that certain hiring examinations disparately impacted African Americans. So the EEOC's efforts to eliminate potential discrimination involving these pre-employment screening tests does have a long history. As I mentioned before, they've fallen out of fashion somewhat as the EEOC has focused its attention in other ways that employers might implement barriers to certain groups looking to get hired. But it will be interesting to see how this theory continues to resurface through the EEOC's litigation in the coming years. As I mentioned, this theory is contingent on proving discrimination through statistical data. And this is just sort of an expensive way of proving a claim. It requires experts, it requires data and analysis of that data. And so this year there was a significant budget increase. The budget is about $465K that was allocated to the EEOC this year. So I wouldn't be surprised if this leads to, a more aggressive use of this theory this year and then in years to come.
Yeah, it's expensive for employers to defend against them too, because it necessarily requires your own expert. And the EEOC is getting much better at litigating these statistical cases. Andy, let me throw it over to you. AI-related discrimination.
Yeah, so as mentioned before, the EEOC is interested just generally in AI, and in particular, seems to be on sort of a tour around the country, making sure employers understand that just because a human doesn't make the decision doesn't mean you can't be challenged if the outcome of that decision is discriminatory. So mostly they seem to be on a campaign to get that word out as an initial step. But they did also issue guidance specifically as to disability discrimination and how AI can facilitate that. And so employers need to take steps to make sure that they're not screening people out. So some of the things that are covered in the guidance are making sure that whatever system you are providing for your applicants or employees, that they're actually accessible to people with disabilities. So, somebody who has a vision impairment, are they able to use screen readers or some other technology in order to use that tool? Or the assessment metrics. So if the assessment is measuring how quickly one clicks through in order to decide whether somebody's qualified for the job, is that having an impact on those with disabilities? So again, this is one of the areas where the EEOC has gone a little bit further out in terms of talking about what employers should do rather than just issuing a general caution. But we might see more guidance from them on other topics related to AI as we go forward.
Thanks, Andy. Yeah, this is one of those sexy topics that the EEOC is swarming right now, getting a lot of media play with this as well. Kate, can I have the next slide? And while we're transitioning, I managed to misspeak. My producers told me we've managed to misspeak the CLE code. It's 6559. SS 6559. Sorry about that. Okay, things to come. What we think is going to happen here in 2023. If we could go ahead and just drop the slide, please. And let's go around the table, meet the press style. Matt, maybe we could tell me what your prediction is for 2023.
Yeah, I will keep hammering the same points I've been hammering this entire webinar. I think it's the interplay between the Bostock decision, the LGBTQ issue, and how that's going to play out in workplaces where some people will believe or do sincerely believe that some employer policies meant to implement the aspects of that decision will conflict with their sincerely held religious beliefs. I think navigating that issue is going to be intense, very difficult. It's going to be maybe not unlike the COVID vaccination requirement issue that employers around the country had to grapple with over the last few years, potentially even more problematic than that and long lasting. The other one, I think, and I've said it before, I think is the equal pay issue. I continue to believe, I've been saying it for years, and I continue to believe that that is just a key issue for the EEOC. I think that it was a little bit on ice while the commission was under the influence of the last administration. As Andy mentioned, we have the pay transparency law is going to even bring a bigger spotlight to this issue. I continue to believe that's one to watch for all employers. Andy,
What's your pick?
I'm going to keep hitting the artificial intelligence drum. They're really interested in it. I'm not sure that we'll see a spike in litigation on this front this year, but what I think will happen is that there will be more probing during regular charge investigations to find out whether the employer is using something that the EEOC wants to scrutinize more closely. I think they're looking for those test cases. It takes a while to unearth. I was just re-listening this morning to a podcast that Keith Sonderling did where he talked about, commissioners have the right to bring their own charge if they want to. And sometimes the way they figure out what they want to pursue is by reading the news or watching 60 Minutes. So I think that they have their ear to the ground. They're trying to find the right case to kind of advance these theories. They want people to be on notice that they need to be careful in their use of AI. I also think just whatever the topic, I think we are going to see much more litigation this year. I think once we have 5 commissioners and the barrier to getting approval to go forward on litigation is gone, that we're going to see that around the country they're holding back on some cases and they're going to be ready to press forward.
So for our listeners, or viewers, if you might want to push out to the folks that are actually handling the charges, you're getting an RFI that specifically calls out AI, and we've seen anecdotally this start to happen around the country. That's something that should get escalated to you. It shouldn't be handled in a routine charge fashion. Those are hot spots, so it's something that you should have your finger on the pulse of. Sarah, what do you think is going to be the next big thing for the EEOC in 2023?
Well, I don't know if it'll be the next big thing because I feel like it's always been a big thing, but systemic discrimination cases, and for those who aren't, familiar with the term, that's just defined as a pattern or practice, policy, and or class case where the discrimination has broad impact on an industry, a profession, a large company, or just a geographic location generally. The EEOC is attracted to these cases because it does tend to bring a lot of media attention. It also, tends to generate more money for the victims. And so, for those 2 reasons, it's kind of an obvious pick. And just an interesting note. So when the 2023 budget was announced for this year, which I mentioned was a significant increase, Commissioner Burrows specifically justified that number, given, in her words, the Biden administration's call for a whole of government approach to addressing systemic discrimination and advancing equal opportunity. So I think that will definitely be a focus going forward.
And an area that is ripe for systemic treatment is reductions in force. We've seen it, it's cyclical. We've seen it happen in previous downturns, and I'm not suggesting we're in, some industries are in better shape than others, but if you are an industry that you have a lot of turnover in the form of reductions in force, plant closures, that sort of thing, the EEOC is looking at those, and it's a potential area for EEOC systemic treatment. One last thing that we said we were going to talk about is some best practices, and it actually, it's interesting. We've got a lot of questions on this as we've been going along in terms of what you can do to insulate yourself from EEOC enforcement. Some of this is going to sound basic, but it bears repeating. State-of-the-art policies. Look, if you haven't looked at your handbook in the last couple of years, you need to take another look at it. There have been so many state and federal law changes. You got to take a look at that. It's an area of vulnerability if you realize after litigation is filed that, oops, we don't have the best of the best policies. The EEOC has given a roadmap in a lot of areas like disability discrimination, accommodation, best practices. I'm not saying you have to incorporate all of those. The EEOC can be wildly overreaching, but the more you can track what the EEOC wants to see in your policy, the better. Training, it's one of those things that I just beat the drum all the time. And it's not just off the shelf training all the time. You can do some targeted, customized training where it needs to happen. Make sure that you're covering all the protected classifications. And if you're in an industry that's particularly vulnerable, again, I mentioned hospitality, doing more training than you usually would can't hurt. You might think, oh, well, what am I'm going to get a bunch of charges because I'm educating everybody on this. It's much better to deal with it at that level and have the narrative that we trained people and they found out about their rights because you went to them and showed them what their rights were. In terms of the tech industry, for example, an extra push on age discrimination, training, gender equity, there's a lot of those issues. So just be mindful of what is attacking your industry and do some additional training on it. Link it up to, you don't have to do a standalone 4-hour training for everyone. You can add it on to other rollouts of policy changes and training when you go along. Somebody asked me earlier, does my policy have to say that you have an avenue to report harassment outside of the company? Does it have to say you can go to the EEOC? It doesn't have to. And a lot of times what your policy violations are much broader than what federal law protects. So to answer that question, if you have you can always call the EEOC. I think the EEOC would be delighted to see that in your policy, but it's not required. The final thing that I wanted to mention is monitoring your charge data. For some of you, we're talking about 10 to 15 charges a year, and that's pretty easy to keep an eye on. For others, it's hundreds of charges, and you have folks at a regional level or maybe even a local level handling those charges. The danger there is the EEOC will sometimes pluck a number of different charges out of a region and put them together without you even knowing it. One question we got earlier was, I've got my charges transferred from one region to another. What should I read into that? The answer is 90% of the time, nothing. It just means that they didn't have enough resources in a particular office to do it. So I'm not being an alarmist, but if you start seeing all of your charges rolling up to one investigator, even though it might be somebody in Nevada and then California, and then next thing you know, though, it's all feeding up to a regional, on a regional level to a particular city, be mindful of that. And if you see that you are being communicated with by a systemic investigator, those are folks that are specifically trained to look at systemic issues. That's something that should put a red flag up. Doesn't mean you're doing anything wrong. It just means you got to pay extra attention and make sure that you're not just putting out a cut and paste position statement or request for information in those situations. So just be mindful of what's going on with your charge data. Okay, next slide, please. What we wanted to show you is just the book again. This is some of what we've talked about today is in the book, but there's reams of information in there beyond what we talked about today. And we invite each of you to take a look at that. And if you have any questions, obviously you can reach out to any of our panel. A big thank you to a lot of other people, including this group around the table was responsible for this book, but also James Nasiri and a whole host of others at Seyfarth that helped out with that book. It couldn't be done without them, and I hope you all find it useful. You can also track a lot of cutting edge current trends in workplaceclassaction.com, our blog post that I think a lot of you are already on that mailing list, but if not, just reach out and we can make sure that you're on that as well. If we take down that slide. So Thank you. Thank you to also to Kate Stacy, who's our producer today, that made sure everything work right. And we hope that you will all join us. We do a fiscal year-end report in September, but we're also going to be rolling out a handful of other more targeted webinars over the course of the year, including some discussions with potentially some commissioners that can give you their thoughts. But again, thank you all for attending today. Let us know if you have any questions, and we look forward to keeping you in the loop with our various resources. And thanks to all of our panelists.
Thank you.
Thank you to our presenters. This concludes today's webinar. Thank you all for attending.